Good evening and welcome to this session of the live coaching classes conducted by the Board of Studies of the Institute of Chartered Accountants of India. I'm yet to see the messages. I'll just sign in and then I can maybe do that. Give me 1 minute to sign in again. Questions. Yes, sir. So we have Alok here. Welcome, sir. Mitesh Bhai Patel, Mr. Patsadi, good evening. And Manoj Kumar Thakur, Jnanesh is here. Welcome, Jnanesh. And yet my good friends Abdul and Aslam yet to come. I hope they'll come in. In the meantime, let me begin with my usual prayer before Aslam comes in and wants me to do it. Sahana Bhavatu, Sahana Bhunaktu, Sahaviryam Garvavahai, Tejasvinavadi Tamastu. Ma vidvishavahai. Om Shanti, Shanti, Shanti. So welcome back, and today we continue. Hopefully today we will complete the management and administration topic. It's very lengthy. That's why we have been given 4 sessions to do this. Aram se. So good. I have Ms. Gomati Krishnan. Good evening, madam. Good evening. New name. Okay, welcome. Gomati. Priyanka ji, wow, welcome. Good morning. Hello, good evening. Okay. See, she's studying so hard, she doesn't know whether it is morning or evening. Wow, great. Chalo, I'm just pushing these slides to go to where we went. I think we completed quite a lot. I think we crossed 100 the other day. And actually 169 slides, can you imagine? And that's only one PowerPoint. There's one more PowerPoint to go today. So, but luckily we've gone through the 4 methods of, just for reiteration, there are 4 methods of voting. Correct? Voting by show of hands, voting on poll, when you get a ballot sheet, physical, you mark and you write your name, registered folio number, etc. Or sometimes they may pre-print it and give it to you. You mark your decision for or against for each resolution, fold it, put it in the ballot box, go, scrutiny has come, take care, you saw all that. Another is voting through electronic means, where instead of physical form, you are given access to a site, URL, where the same thing, you will go through your user ID and password given through the DPID. It will be sent to your email, which is registered with your depository participant. And automatically you will get it in your email, you will know your user ID password, and you can enter the site, vote, submit, come. Then the scrutineer will collect it. The share transfer agents will have a software. It will all be dumped into an Excel sheet, analyzed. There will be an analytical software. Result will be announced. Totally electronic. Then, of course, we have the good old voting through postal ballot, which is also there. See, in postal ballot, there is a small issue there, which we saw yesterday. That is, there are certain matters which, according to the central government, shall be done only by postal ballot. Okay. And there are other matters which may be done. Except 2 matters cannot be done. Those businesses which are ordinary business, you cannot do it by postal ballot. And any business in respect of which directors or auditors have a right to be heard cannot be done by postal ballot. Reason is, you should have a physical meeting when the director or auditor will come and ask questions or give his explanation. Similarly, ordinary business, the 4 matters, you need to have an AGM physical. You can't do it by postal ballot. Virtual meeting allowed. Virtual meeting allowed because in virtual meeting, you will give an option to the members to come to a physical space. And you will give them an option to attend virtually. Today, that is one possibility which is extraordinarily good. In fact, for my daughter's marriage, I had complete, online streaming. I had an excellent photography team who streamed it online onto their website, and we sent the URL link to all my most of my relatives are abroad. On my mother's side, everybody is in either US or Canada, and my Samandhi side, my daughter, the boy side also. So everybody is sitting there watching from the URL. So I got so many emails, messages, and all saying we are enjoying the wedding better than if you are in person there, because we are able to see the marriage as it is going on the stage, like that. So the point I'm trying to make here is virtual meetings are possibly better and hybrid, where some people come physically and others are online. They vote. voting is done by e-voting. So those cases, no problem. Even ordinary business can be transacted that way. But you cannot do postal ballot for ordinary business and for those matters which have directors or auditors have a right to be heard. For example, we saw the removal of auditor. You remember? Removal of auditor before the expiry of his term of office cannot be done by postal ballot. Similarly, appointment of an auditor in the place of those retiring cannot be done by postal ballot because it requires, it's an ordinary business. Okay. Maybe if an auditor resigns and you want to reappoint that auditor, appoint an auditor in his place, resignation only members can appoint. Remember, that is a special business and it is a ordinary resolution and it requires it can be done by postal ballot because it's not an ordinary business. Also, it is not one where the auditor has any right to be heard. He has resigned and gone, this fellow is to be appointed. Can be done by postal ballot. For your information. Okay. Good. So, wonderful. Just recap, quickly moving on. Hey, much of this theory part, it is waste. Don't waste your time trying to remember this type of whole stuff. And again, remember, once you know the scrutineer rights, duties and all for ballot, same thing for postal ballot and e-voting. Mutatis mutandis. Mutatis mutandis. Also try to remember these matters which have to be done only by means of voting through postal ballot. I took you through it the other day. Chalo. Now we move on to section 106, which deals with restriction on voting rights. Right? Restriction on voting rights. So we have Jnanesh. Yeah. Pranav is here. Very good. Pranav, Shubhangi Goyal. Welcome, madam. Okay. So notwithstanding anything contained in this act, the articles of a company may provide that no member shall exercise any voting right in respect of any shares registered in his name in the following circumstances. So this section 106 is superior to all other sections in the act. Whatever may be stated in that section, it will never contradict with this section. You cannot say, sir, that section says like that, sir. This is what to do, sir, like that. Okay, so in those cases, this section will prevail. If any, so in which circumstances will there be restriction on voting rights? For example, if any calls or other sums presently payable by him have not been paid on such shares. If any calls or other sums have not been paid, anything due from him has not come. Mostly it will be calls only. From qua shareholder, what could be? Please be careful. He should be owing money to you as a shareholder, not in any other capacity. Sorry. So, as a shareholder, if he owes you any money, if it is not yet paid, then you can restrict his voting rights. So, if there is any calls in arrears, you can restrict voting rights. If the company has exercised any right of lien with regard to such shares. Now, what is the right of lien? See, suppose now the situation is different. He owes you money, then the company has a right of lien. The company can retain the share and prevent it from being sold. So in those cases also, there will be a restriction on voting rights till he pays the amount. Okay. A company shall not, except on the above grounds, prohibit any member from exercising his voting right on any other ground. Okay. So this is restriction on voting rights. Remember, every member has one vote on show of hands. That is one person, one vote. But on a poll, one share, one vote. You know this already. So if you have 200 shares in Reliance Industries Limited, on a poll, you have 200 votes. On a poll, you have 200. So when you put your yes, it is 200 yes. Of course, when Mukesh Ambani puts it, it is so many 1,000 lakhs yes. Okay, shares. Because as many shares, as many votes. On a poll taken at a meeting of a company, a member entitled to more than one vote or his proxy were allowed, or other person entitled to vote for him, need not, if he votes, use all his votes or cast in the same way all the votes he uses. Think about it. On show of hands, one man, one vote, no problem. But once you split, once you go for a poll, you are having 200 votes. Now, you are the member, you can decide, or your proxy, or any other person who is your power agent or whatever who is entitled to vote can vote in any manner. 200 votes he can split. 100 for, 100 against, 150 for, 50 against. Why he will do it? Please don't ask me. He can do it. He can use all his votes are cast in the same way. He need not, if he votes, use all his votes are cast in the same way, all the votes he uses. He can decide for so much, against so much. Are you able to understand? Normally, nobody will do it in that. They have given the provision. Okay, I'm not able to think of one situation where this, unless he has some kind of a friendship with people and say, hey, I'm voting for you, 50 votes you'll give him. Hey, boss, I voted for you only, man. Another 200, 150 he will give to the other fellow. I don't know why he will do it, but he can do it. Joint shareholders must concur in voting unless the articles provide to the contrary. Usually, or rather, Table F articles are very clear. They will provide that articles can provide that if there is case of joint shareholders, the first mentioned holder will be the who will decide the vote normally. Otherwise, they should concur. The voting concur means they should all agree on one vote and they should vote together. The voting in case of joint shareholders is done in the order of seniority, which is determined on the basis of the order in which their names appear in the list of members. Joint holders have a right to instruct the company as to the order in which their names are to appear in the register. See, normally it is a seniority. Whoever first will decide. Okay. In case they are not decided, then the votes have to be split. If there are two of them, then equal, 3, 1/3. So one fellow will say against another 2. So it depends on that voting. Normally, the board of directors decides the agenda and the resolutions to be proposed at a meeting. See, on show of hands, 3 fellows cannot raise the hand. Only the first guy will raise the hand. Only his vote will be counted. Normally, the board of directors decides the agenda and the resolutions to be proposed at a meeting. This section provides that members too have a right to propose resolutions and submit any statement with respect to the matters referred to a proposed resolution or business. Normally, directors only will propose a resolution. Normally. So, in the notice calling the meeting, agenda will be there. But in some cases, the members may feel we want to propose a resolution. It could be anything. See, usually this 111 will come into play only where, remember one more section, EGM by requisition of members. Only in those cases, they will also want to circulate. Okay, so they may try to circulate it and then they will call whatever. So circulation of members. So when the members are unhappy with their directors, they might send the resolution or they may submit a statement with respect to the matters referred to. See, you are trying to pass a proposed resolution. For example, I'll tell you a simple example, very silly but simple example. It happens regularly. You are trying to increase the salary of your managing director. For that, you have to go to the members for getting special resolution, etc., etc. So you go to the members. Members feel that the company is being mismanaged by this fellow and that already whatever salary we are paying him is not worth it. Why pay some more? This is the view expressed the members. So when they see that appointment and they see the higher salary, they get angry. So they want to send a statement. What all the nonsense this fellow has done. He has caused loss to the company. Company is making losses. Why pay him salary? And that too, why increment? All sorts of questions will be asked by them. Statements can be done. They can do it. They can propose, or they can even propose a resolution saying he should be removed. Like that. Of course, complying with the provisions for applicable there. Of course, you can always propose a resolution that he can be removed as managing director without removing him as a director. Because if you want to remove him as a director, there are some special provisions to be complied with, which if done, you can proceed with that also. Now, so whatever it is, the resolution and statements received from the requisite number of members, we'll see what is that requisite number a little bit later. The requisite number of members as specified in section 100. Remember 100? What is 100? I don't know. I'm sure by then Aslam would, if Aslam is here, he would have given me, sir, 100, I know, sir, like that. Huh? You know where we'll go back? 100. We'll go back to EGM at the requisition of members. This is the requisite number. This is the requisite number. Just I'm coming back for this. Same requisite numbers for 111 also. Okay, same requisite number. Once you remember this, automatically there. If you remember it, not less than 1/10 of the members holding not less than 1/10 of the paid up share capital as on that date carries right of voting. In the case of company not having a share capital, members who have not less than 1/10 of the total voting power, right? So this is how it is. Coming back to 111. Sorry for shifting the screen again and again. I hope it's moving fast. Yeah. So a resolution is to be proposed, and the requisite number of members as specified in section 100 have sent to the resolution. Then it shall be circulated by the board to all members entitled to notice of the meeting and shall be taken up at the meeting. Whatever it may be. See, as I told you, the job of the chairman is to ensure that all resolutions are taken up, proposed, seconded, and voted upon. Then whatever happens in the voting, so the members will give a statement saying this donkey MD should not be appointed. He has already caused enough damage to this company. Don't appoint him or remove him. Resolve that. So and so be and is hereby removed as managing director of the company. Resolve further that company proceed against him for recovery of unlawfully money or recovery of compensation for loss caused to the company. Blah blah blah. You decide whatever resolution you want. Draft it, send it along with the you send it to the company. A company shall, on requisition in writing of such number of members as required in section 100, give notice to members of any resolution which may properly be moved and is intended to be moved at a meeting, and circulate to members any statement with respect to the matters referred to in proposed resolution or business to be dealt with at the meeting. Beautiful. Absolutely correct. A lot of people have replied to my question. EGM done 1/10 of paid up capital. I don't know what done is. Good. So once we get this requisition, you should give notice to the members of any resolution which may properly be moved and is intended to be moved, and circulate to members any statement. See, a statement can be given even without a resolution. There may be a resolution proposed to be passed. You want to give some further information about it, you can give it in the form of a statement. Nothing wrong. It has to be circulated. What is the time limit? The time limit for deposit of requisition together with a sum reasonably sufficient to meet the company's expenses. See, this is not the company's job. They want it to be circulated, we will do it. But we don't have to bear your expenses. You give us, deposit the money along with the requisition. I will use that money to send. So we will estimate the postage charges and maybe add another 10% buffer and say pay. Whatever. So the requisition should be deposited. If it is a requisition requiring notice of a resolution, 6 weeks before the date of meeting, 6 weeks before the date of meeting. Okay. So 6 weeks before the date of meeting. Now, obviously, my dear friends, how will I know when the meeting will be held? So what I will do is, I will deposit the requisition in the hope that maybe nearing the AGM, I will deposit it. So that when the meeting is held, I would have deposited it well ahead, before 6 weeks. Minimum 6 weeks before you have to give. A requisition requiring notice of a resolution. Only then they can consider it, get legal opinion. Then when they draft the notice of the meeting, they can include it and call the meeting 21 days now. So you are giving another 21 days before. So they have 21 plus 21, now 6 weeks. So the 21 days, the 3 weeks that you're giving them extra bonus days, they will use it. Though, we don't use 3 weeks. We say 21 clear days. You are giving it 6 weeks before. So he has enough time to decide what to do, plan, get consultation, and then include it in the agenda itself. Then no problem. He doesn't have to go around circulating it. But suppose no meeting has already been called. You are not asking for a requisition. You just want to circulate a statement. Then it should be deposited at least 2 weeks before the date of meeting. 2 weeks before the date of meeting. Then, of course, it's the duty of the company to circulate. Okay. So this is how it is. Again, in both cases, for date of meeting is where you have to look at. Any resolution, requisition requiring notice of a resolution 6 weeks before the date of meeting. Any other requisition 2 weeks. So that once the company gets it, it still has time to circulate to the members and things. A copy of the requisition signed by the requisitionists or 2 or more copies, which between them containing the signatures of all the requisitions, every requisitionist should sign. Requisitionist, they should sign. Shall be deposited at the registered office of the company within the time limit prescribed above. Deposited means either by courier or in person you have to come and give it. If after a copy of the requisition requiring notice of a resolution has been deposited at the registered office of the company, an AGM is called on a date within 6 weeks. The copy, although not deposited within the time required, shall be deemed to have been properly deposited. See, you know that normally there is the AGM would be held in the month of say August or September. So what you do, you go ahead and you deposit it on the 14th of August, thinking that anyway they'll be holding it only in September like that. These fellows go and hold the AGM within 6 weeks. Then, even though it was not deposited within 6 weeks, it shall be deemed to have been correctly deposited, properly deposited. Because you cannot anticipate that they will hold it early. And if they do it wantedly, then your requisition should not suffer. Therefore, they say, if they are holding it less than 6 weeks, then it should be deemed to have been properly deposited. The company shall not be bound to circulate any statement if on the application, either by the company or any other person who claims to be aggrieved, the central government, in this case the regional director, declares that the rights conferred by this section are being abused to secure needless publicity for a defamatory matter. We already saw that when we spoke about auditors. See, whenever you wanted to remove an auditor before the expiry of his term of office, you gave him an opportunity to make any representation in writing. Now, if in that representation he keeps on making defamatory statements, defamatory means anything that will reduce the respect of the person in society. So, you cannot misuse this right, okay, for securing needless publicity for a defamatory matter, right? I give my own original example. You got a managing director, you feel that he has not managed the company properly. Now you want to give a statement that any increase in remuneration should not be considered. That's all. And you want to give valid reasons why. Maybe you got some data also. You keep giving. Last 5 companies, the company has incurred cash losses. Like that. Okay, because negligence has been. Most of the time he has been out of India. We have never seen him in India. And he is maintaining NRI status. But still you want to pay him more salary, so nothing wrong in this. There is nothing defamatory about it. But suppose the requisition is, simply motivated by anger and jealousy against that person. They say he is a donkey. He doesn't have any culture. He wants to grab the money and run away. He is a crook. See, these are all unproved statements. Defamation. You cannot use this method for securing needless publicity for a defamatory matter. Who will decide it? Suppose the company or the MD himself will make an application to the CG, that is the regional director. If the regional director reads it, he will say, what is this? Like, yes, sir, what to do? They are doing like this. So he will give a valid reason. Then immediately RD will say, no. And any cost incurred by the company for coming to the RG, etc., hiring companies, chartered accountant, shall be paid to the company by the requisitions, notwithstanding that they are not parties. Because you created the problem, you sent this defamatory statement. Then they had to hire the lawyer, they had to hire somebody, come to me. All the fees, you bear it. So RD will say, pay all the costs incurred. You have to pay, right? Which is why the statement and all, they are all double-edged sword. Have to be very, very careful. If you want, be very, very polite. Be very, very cultured in the way you behave. Okay? So that you won't get into defamation issues. Okay. So here there's a penalty. If there is any default in compliance with 111, then penalty of 25,000 for the company and every officer. Right? Now we go on to something that you are already quite familiar. I have taught this to you even as early as share capital. What is ordinary and special? Still, we will quickly go through it. Before we go there, please understand the difference between a motion and a resolution. Okay, a motion and a resolution. A motion is proposed, seconded, and put to vote. Please understand. I gave you examples yesterday of voting and all that. So every time I said, do you remember I did not use the word resolution? I kept on using the word motion. I kept on saying, gentlemen and ladies, you have heard the motion being proposed and seconded. All those in favor. So motion is what is moved at a meeting. I repeat, motion is something which is moved at a meeting. Moved means it is proposed and seconded, and chairman takes it and puts it to vote. Once it is voted favorably, it becomes a passed, is a resolution passed. Otherwise, it is not passed, defeated. Motion is defeated. Once a motion is passed, it is a resolution. Got it? For your information. A motion, when passed, becomes a resolution. So till it is passed favorably, it is a motion. I mean, very subtle. Again, it's more of a semantic English language issue. Is it wrong to use resolutions? Or you can, I think wrong. But if I were speaking, I would not use a resolution when it is proposed and seconded. And I will not use motion after it has been passed. 2 stages. Okay, sir? There are 2 types of motions. A substantive motion and a procedural motion, for your information. Substantive motion pertains to item of agenda. For example, we have the 4 ordinary businesses, then any other business, which is special business. These are all substantive motions. They deal with the item of agenda. Procedural motion relates to conduct of meeting. Yesterday, we saw so many procedural motions. 1, motion for adjournment. Motion for poll. You remember? The proxy says, Mr. Chairman, I demand a poll. Another proxy stands up and says, Mr. Chairman, I second the motion. That's it. Motion has been proposed and seconded. Now you have to take a poll. Okay. On a poll, no. I mean, on the substantive motion, you have to take a poll. The proposal to take up the poll, okay, is a procedural motion. That has to be put to vote, and then the poll has to be taken. Election of chairman, procedural motion, etc. Okay. A substantive motion, when approved by the required majority, is said to be passed. Usually, procedural motions are not normally put to vote. The chairman takes the call on the procedural motion. In some cases, it will be put to vote. And it's better for the chairman in some cases to put it to vote. Okay. And get the concurrence. But if it's a simple matter, he will say, go ahead, proceed. No problem. So that is all. These are all procedural motions. Right. Now, you know what is an order resolution. I don't want to trouble you with explanations again and again. 111. Sir, I have explained. Again, don't ask me to explain, sir. What were you doing when I was explaining? I was elaborately explaining it. Again, how can I do it, sir? Shortly, I'm giving it. Listen, see, this Vedant Varaji, see, the problem is you people are not concentrating when we are talking. And then you say, explain, explain, explain. Secondly, language issue. So concentrate on what I'm saying now. You are a member. You want to propose a resolution. You want to propose a resolution, Baba. You want a resolution to be taken up at a meeting. This is the procedure. Requisite number of members should make an application. What is the requisite number? As per section 100. Yaad hai na? Section 100, you go and find out. 1/10 of the total voting power, 1/10 of the paid up share capital. Come here. If that requisition is received, then company shall circulate it to all the members. The resolution. Also, a meeting of the company may be called. One of the resolution is there. You are having some issue about that. You want to make a statement. So you can send a requisition asking the company to circulate the statement. So either you can requisition for circulating a resolution to be passed at the meeting, or requisition for circulation of a statement. If you want them to include a resolution, then it has to be done 6 weeks before the date of meeting. 6 weeks before the date of meeting. Any other, where you want to just circulate the statement, 2 weeks before the date of meeting. Got it, sir? This is the crux. Obviously, I cannot guess when these fellows will hold a meeting. So I take a risk and I deposit my requisition for passing of resolution. Then these buggers hold an AGM within 6 months, 6 weeks. Then even though technically it was deposited less than 6 weeks, it will be as if it was deposited correctly, properly. So this is broadly speaking what it is. This needless publicity, if you don't understand, you leave it. Okay. So this is what penalty I think you will be able to understand. Okay, sir? You got it? Yeah. Just confirm that you have understood it. So Pranay Vasisha says bill. Exactly. Motion is like a bill. A resolution is like an act. A good comparison. I'm not able to question it. Again, Abdul makes a very valid point. Every resolution was a motion. Is a motion, may be wrong, was a motion. Every resolution was a motion. Okay. But not every motion may become a resolution. I think the tense becomes very important. Every motion, every resolution was a motion. But every motion may not become a resolution because it may be defeated. So if you change the tense, in both cases you are using is. If you change the tense, then your sentence will become better. So you know what is an ordinary resolution. Okay. First of all, the notice calling the meeting should specify correctly. It should be given as per the act. Then the resolution should be proposed, seconded. There is a motion should be proposed and seconded. Substantive motion. Then the votes are cast. The votes cast in favor of the resolution, including the casting vote, if any, of the chairman. Do you remember casting vote? By members who being entitled to do so, vote in person, or where proxies are allowed by proxy or by postal ballot. So whether by show of hands or whether by ballot or by postal ballot, whatever it is, the number of votes cast in favor, including the casting vote, exceed the votes cast, if any, against the resolution by members so entitled and voting. Right, sir? Now, one more point that you might want to remember, I already gave you this example. Check out. When you come to special resolution, I'll give you a better example. This is simple, yeah. 5 people attend. 5 people attend. 2 against, 3 for, motion passed. Resolution. 5 people attend. 2 for, 2 against, 1 neutral. Listen carefully. 5 people attend. 5 people attend. 1 is neutral. He is not voting. 2 for, 2 against. Chairman has already cast his vote for. Chairman already cast his vote for. So including chairman, 2 for. Other than that, 2 against, 1 neutral. Now, it's a tie. Now the chairman can give his casting vote. Because he is for now. So again, he put another vote, casting vote. With that, 3 for, 2 against, 1 neutral. Motion passed. Ordinary resolution. You got it? So chairman's casting vote is an additional vote. Okay. And why Vedant Vora, you are always typing your questions 2 times, I don't know. So, sir, a member will propose a resolution, and if certain limit of requisites agree to this, no, you need a requisite number of members to make the requisition itself. Means members holding 1/10 of the paid up share capital should make the requisition. You remember, na, requisition is meeting. Same. For holding a meeting, the requisition is sent. Here, you are sending the requisition for proposing a resolution at a regular meeting. So you are saying you are anyway going to hold a meeting. At that meeting, propose this resolution. That's all. Or you are going to hold a meeting where you are going to pass that resolution. In connection with that, circulate this statement. That requisition should be proposed or sent by the requisite number of members. Once it is received from the requisite number, then the duty of the company to circulate it. That resolution will be circulated. At the meeting, the chairman will take up that matter. Then voting will happen. If it is passed, passed. Defeated, defeated. Okay? You got it? No. Don't. No confidence movement is a totally different thing. Please, I don't know why you are all bringing constitutional law into this unnecessarily. This is company law. If you want to learn constitutional law, tell me, I'll take separate lecture. No confidence. Have you read the constitution? No confidence movement. You know what it is? If you know, then you should not compare it with this. This is simply a resolution being put to vote and defeated. Yeah. Motion is put to vote, defeated. That's all. No confidence is totally different. Okay? Don't confuse. Manoj, are you preparing for IAS exam or something? You are so much up to date on constitutional law. Don't waste your time. No need to compare. Yeah, you understand this separately. See, bill, act, chalo. Motion, resolution. Don't keep on extending the metaphor and giving like. No confidence moment is a totally different thing. This is just resolution being proposed. Now, votes against are now more defeated. That's all. There's no great thing about this. Mr. Chinmay Das, you are continuously putting words and monosyllables. I am not able to understand what you are putting at all. Evidence, guide, prevention, deviation. What are you doing here? Are you part of this session? Are you able to write? What is it you are putting there? Evidence, guide, prevention, deviation. Some word game you are playing. I don't know what you are doing. I'm not able to understand. Maybe you are clear about what you are putting. I am not able to understand. No special resolution. Please, folded arms. You are seeing Srikanth doing this. Folded arms. Why? Don't please say 3/4, 2/3. Please. Folded arms once and for all. I am begging you. Don't say 3/4. Please. Erase it from your mind. It is not 3/4. Vote cast in favor. The intention to propose a resolution as a special resolution has been specific mentioned in the notice. The notice calling the meeting should very clearly say to be passed as a special resolution, or to be passed if approved as a special resolution. Very specifically. Ideally, you should put special resolution in the cap so that people will know that this is a special resolution. Got it? Votes cast in favor of the resolution, including the casting vote, if any, by the chairman, which is stupid. There is no need for a casting vote in special resolution by members who being entitled so to do vote in person. See, one thing, you can have a casting vote in special resolution. You can have a casting vote in special resolution. When? Anybody? Chairman can exercise a casting vote in special resolution. When? Can I have an answer? Chairman can exercise casting vote in special resolution. When? Okay, let me ask you a question. Okay, we'll have the definition which you are quite familiar with. I don't want to. You are all experts in special resolution now. So anyway, we'll go through. Or where proxies are allowed by proxy or by postal ballot, the votes cast in favor of the resolution are required to be. See, this is nonsense English. Nonsense English. I don't know why they do like this. See, here they say exceeds correctly. All that they have to say is votes cast in favor of the resolution, blah, 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 shall be not less than. That's all. Why they use the word are required to be? Because they are thinking in Hindi. That is, I'm sorry to use that word, but thinking in vernacular, translating it into English. Sorry to say. Are required to be. Padega, are required to be. Karna padega. Why? Okay. So votes cast in favor of the resolution shall be, but unfortunately the section uses the word are required to be. Not, see, I'm sorry if I sound a little angry, but problem is I'm a purist in the use of English. Try to improve your English. Humble request all of you, again, it's folded arms. I know you people studied in schools where English was not stressed, where possibly English was not given importance. Nothing wrong. It's a beautiful language. Start learning it now. You can improve it. You got time. You are, how old are you? I'm 57 years old. I'm learning one new word every day. Okay. I'm improving my vocabulary every day. Right? 57-year-old man continuously learning, reading, improving myself. Not because of getting more money, earning more money. I've earned enough money. Because I'm an intellectual. Because I have a brain. Because God has blessed me with a brain. And it is my duty to improve my brain. That's all. It's a duty I owe to God for creating me. Nothing more. Okay, He has given me the body. Nallador Vinay Seide, idai Nalangada Purudi Lerivadundo. Soladi Sivashakti. So God has given me the body, mind, and intellect for His service. So I have to keep on improving it. Not because of earning money. Money will come. Because this body, mind, and intellect should be put to His service. And for that, it has to be improved. Think like that, you will start improving your English automatically. Because if you are fluent in English, you can represent your clients better. You can serve society better. You can do better things. You can write books. Our past president, T.N. Manoharan, Padma Shri T.N. Manoharan has written a book on Satyam. Okay. It's called Phoenix, IT Phoenix, Technology Tech Phoenix. Beautiful book. So see, he continuously improves himself by reading, by learning. He is our role model. Like that, you should also read and improve. Okay, your English. That is why when I see bad usage of English like this, I get very upset. And that too, when in a statute, when the parliamentarians should have known better, I feel a little upset. I'm sorry if I'm reacting too much to this. Anyway, so votes cast in favor of the resolutions are required to be not less than 3 times the number of the votes cast, if any, against. Okay. Sir, if number of votes are equal to 3 times, no problem. Yesterday I asked that question and it was correctly answered by Abdul. Correctly, Abdul gave the correct answer yesterday. Okay. That is, when the number of votes cast in favor are exactly 3 times, the resolution is passed. Not less than 3 times, he says. So, if it is exactly 3 times, then it is passed. Now the problem will come. I'll give an example, you will understand. 8 people attend the meeting. Make note of the numbers. Now, 8 people attend the meeting. How many people? 8. Voting by show of hands. Let's keep it simple. Let's not get into balloting. There's no need. Only for principle case sake, I'm giving this example. 8 people attend the meeting. In person. 8 in person. Quorum is present. Don't confuse that. Quorum is present. Okay. 8 people attend the meeting. And 5 are... 8 people attend the meeting. 5 are in favor, 2 are against, 1 neutral. 8 people attend the meeting, 5 are in favor, 2 against, 1 neutral. He votes neither for nor against. Have I passed a special resolution? 8 people attend the meeting. 8 people attend the meeting, 5 are for, 2 are against, 1 neutral. Have I passed a special resolution? This is the question. Any answers? No. Correctly answered. Abdul is an expert in resolutions. No, sir. Thank you. Correct. Why? Because votes cast against are 2. The votes cast in favor should be not less than 3 times the number of votes cast against, if any. So 2 into 3, 6. So minimum I need 6 votes. But how many have I got? 5. One of the 5 votes is chairman. One of the 5 votes is chairman. So chairman is for the resolution. He has voted for 5. 2 against, 1 neutral. Forget him. So now the chairman can cast 1 more vote. Samajh gaya? Now the chairman can cast his casting vote. Then what will happen? With that extra casting vote, this will become 6. Then 3 times. Resolution has passed. This is a situation where the chairman of a meeting can exercise a casting vote for a special resolution. Are you able to understand? Exactly. So it should be 6 now. It's only 5. Now chairman is voting in favor. Now the chairman says, I will vote once more time. He can, because he is entitled to casting vote. That casting vote, if he gives for 6, 2 into 3, 6. As Abdul rightly points out, resolution passed. That is when the casting vote can. Got it? Good. Now, you can also answer these questions. Has special resolution been passed in the following cases? You give your answer. I will not give the answer. I will see the answer and then. 3 members attend the meeting of a private company. 2 members are in favor of the motion. 1 is neutral, none against. 2 members are in favor. 1 is neutral, none against. Have I passed? Two members attend the meeting. 1 member is in favor. The other does not vote. Does not vote. Does not vote. Be careful. 5 members attend the meeting of a public company having 200 members. 3 members are in favor of the motion. 1 is neutral, 1 is against. 5 members attend the meeting of a public company having 200 members. No problem. Quorum is present. 3 members are in favor of the motion. 1 is neutral. 1 is against. Out of 5, 3 favor, 1 neutral, 1 is against. Give your answers. You can just say 1, 2, 3, 1 yes, 2, 3, like that. 1 passed. Correct. Why? Because 3 attend, 2 in favor, none against. So 0. Votes cast against is 0. Okay. So 0 into 3 is still 0. Therefore, 2 is greater than 0. Therefore, passed. So you got the logic right. 2. I have my own doubts on 2. If you are going to argue that, sir, there are no votes against, none against, because this fellow has not voted, none against. So 1 vote, 0 into 3, 3, 1 is greater than 0. Same logic if you say, I am still worried about it because 2 guys are attending, 1 is not voting. Because suppose he says I voted against later on some, in which case minutes have to be clearly mentioned. Okay. Mr. Donkey did not vote. There were no votes cast against. Mr. Monkey voted for. Resolution is passed as a special resolution. You have to, that minutes becomes very, very important. Okay. 3. 2 passed. Okay, I give you 3. But be very, very careful. 5 members attend. 3 are in favor. 1 is neutral, 1 against. 1 into 3, 3. Exactly 3. 3 exactly 3 times resolution passed. That's all we are trying to say. One more problem I gave you, which I will not include. Maybe next time I will include that also. That is 5 members attend the meeting. Same in the third example. I'm giving a different twist. 8 members attend the meeting. 3 are in favor. 5 are in favor. 2 against. 1 is neutral. Then it is not passed. Not passed. But if the chairman gives his casting vote, then it can be passed. There is an extra dimension. Okay. So, good. We did some practical problems. Moving on. We are moving on from special resolution to something called special notice. 115. Normally, we saw notice is given by the company to the members, whereas special notice is given by the members to the company. Just like requisition of resolution to be proposed, just like requisition for circulation of statement, this is one more provision by which the members can require a special notice, meaning certain special subjects if you want to take up at a meeting, the members want to do it, then they have to take it up by giving a special notice. I'll come to the situations later. Right now, let's look at the procedural part. Where any provision in the Act requires special notice, it shall be given in accordance with Rule 23. We'll see Rule 23. Do you remember having discussed, or did we talk about special notice in earlier topic? Anybody? In any earlier topic, did we talk about special notice? In which situation it was required? At that time, I said, if I'm taking management administration, I'll talk about it. It so happens I'm taking, so I will start talking about it. When did we see special notice? In which topic? And for what purpose it was required? Anybody? Let's make it a little interactive. Because you guys are all so intelligent and so and I'm so happy. Abdul is really great, doing fantastic. So happy. So, and I'm missing Aslam. I think he's doing something else, not here. Otherwise, he would have been 100 comments you would have put by now. And I would have also told him not to put comments in. Yeah. When did we see special notice? Quickly. In which topic? Minimum you just put which topic we saw special notice. Which topic we saw special notice. Do you remember the topic? Okay, let me not waste time because they're not going to. Yes. In case of auditor, not reappointment of auditor, sir. Appointing a person other than the retiring auditor at an AGM. Appointing a person other than the retiring auditor at an AGM. Or specifically resolving that the retiring auditor shall not be reappointed. Appointing a person other than the retiring auditor at an AGM. Or specifically resolving that the retiring auditor shall not be reappointed. See, the auditor will hold office till the conclusion of the 6th annual general meeting. He'll be appointed 5 years later. Now, when he's coming up for reappointment, anyway, he cannot be appointed. But suppose his firm is coming up for reappointment for one more term, or maybe the rotation of auditors is not applicable to them, then they can be reappointed, whatever may be. Now the members are feeling, hey, no, don't appoint that fellow. Manar and company should not be appointed. So they want to appoint somebody else. My friend is there. Shaker and company, appoint. Okay. Chalo, no problem, whatever may be the firm. Point I'm making is, what to do? The members have to serve a special notice. I'm not able to remember the section number. Sorry. I am totally zero in the new law section numbers. Okay. Anybody can remember the section number? Tell me. Otherwise, not a problem. Situation, remember. Appointing a person other than the retiring auditor, specifically resolving that the retiring auditor shall not be reappointed. In your syllabus, it is there. This is one. There are only 2 sections, 4 matters requiring special notice in the Act. 2 you saw now. 2 more you will see in the final syllabus. Removing a director at an AGM and appointing removal of director, correct. But that's not in your syllabus. And appointing a director in the place of the director so removed. 2 matters you will find later. Now you are finding 2 matters. Totally 4. So 4 hai. 2 section, 4 matters only. Okay. So wherever in the Act there is a requirement for special notice, that special notice should be given in accordance with section 115, read with Rule 23. Special notice shall be given by such number of members holding not less than 1% of total voting power. 1% of total voting power, or holding shares on which an aggregate of not less than 5 lakh rupees has been paid up on the date of the notice. So special notice should be given by the minimum number, which is members holding not less than 1% of the total voting power, or holding shares on which an aggregate sum of not less than 5 lakh has been paid up on the date. Face value, right? Now, whichever is less. If that is not mentioned, always remember it's whichever is less. So if 1% is less than 5 lakhs, 1%. 5 lakhs is 1% is more than 5 lakhs, 5 lakhs. Okay. So these people, once the requisite number is there, it will be sent by the members to the company, not earlier than 3 months, but at least 14 days before the date of the meeting. See, you know for sure that this fellow auditor should not be reappointed. specifically resolving that the retiring auditor shall not be reappointed. So why wait? You send it in March itself. Okay. But no, it should be sent not earlier than 3 months. Okay. So nearing August. So you can even send it in July. So even if they hold it in August or September, within the 3 months, you would have sent it. Or if you're going nearer to the meeting, you see the notice of AGM, you see, he's going to be reappointed. No, I will not permit it. Immediately you send a special notice. It should be sent at least 14 days before the date of the meeting. At least the resolution is to be moved, which is usually, see, remember, all these matters, the auditor part will be at the AGM only. So this is one matter where it is ordinary business, special notice, ordinary resolution. Appointment of auditor at an AGM is an ordinary resolution. Whereas removal of director is a special resolution. Special notice, special business, special resolution. Special notice, special business, special resolution. Okay. Anyway, you will study it when you come to final. There is no link between these sections. Kindly alag. If you are trying to link it, you will go mad. Whatever is given here, study it alag, separately. If it is given as 2 weeks, please study that 2 weeks. If it is given as 14 days, study it as 14 days. 115 alag hai. Am I correct? 111 alag hai. Alag. Not talak. Alag. Got it, sir? Don't confuse. See, Abdul, your nature is confusion. See, clearly I have given here 115 section. Slide is very clear. 14 days. Why get confused? Why you are linking with other requisition? No. If you want to give a requisition for a resolution to be passed, any other matter, you have to give it under 111. If you want to resolve a resolution that the retiring auditor shall not be reappointed, there the section very clearly says special notice is required. Then you cannot go to 111. You will come to 115. Then it is 14 days. Otherwise it is. How I am so clear and you are so confused, Baba? Have you ever thought about it, Abdul? How this Buddha can be so clear when you are so confused? Simple, because the Buddha does not think too much. What he reads, he remembers. What he remembers, he writes. He gets mark, he passes, he gets rank, he goes away. Why can't you come to this mode of thinking instead of confusing yourself? Who is the sufferer, Baba? You, not the world. Okay, here I am answering your questions. I will answer. I am the duty of a teacher. But think about it is all I am saying. Okay. Slight change. You are already intelligent student. With slight change in your approach, you can get a rank. Think about it. But if you keep on linking, binking, what is this, sir? What is that, sir? How, sir? Like that, then I can give you an answer. If you ask me 1,000 questions, I'll give you 1,000 answers. I will become more intelligent. That's all I can tell you. Okay. Whereas you should become more intelligent. For that, do not confuse yourself. Did I say there is any link with 111? If so, don't you think Srikanth would have told? Be careful, link it with that section like that. Since I have not told, and concentrate on what I am telling. Okay. So clearly 14 days. Alag. 2 weeks alag hai, 14 days alag hai. 14 days count. 1, 2, 3 week. Of course, it will be the same. Yeah. In weeks, you won't have any problem. Only in month, you will have a problem. You got it now. In month, you will have a problem. If it's the difference between days and months, you will have a problem. In week, you won't have. Reason is there are months with 31 days, months with 30 days, like different days. I already asked you the question, na? I think same group I asked the question long ago. And I think you gave the answer also correctly. How many months have 28 days? How many months have 28 days? I think you answered. Most of you know the answer. Okay. All the months have 28 days, Baba. Only, see, February is the month which has only 28 days. All months have 28 days. Okay. Can the voting be done by more than one method for a meeting? That those members who voted through electronic method shall not need to vote again. Yeah, see, postal ballot, separate. Balloting, separate. Balloting will happen in a physical meeting. If you are having e-voting, then you can have a physical meeting where normal balloting will be done. No. If you are using e-voting, you can have a physical meeting. Before the physical meeting, there will be a small window for e-voting again. but the voting will be done only by e-voting. If you don't want e-voting, then ballot at the meeting. Okay. You cannot mix and match. You cannot mix and match. Either you do pure balloting, everybody comes, ballots, puts it, goes, or else you do e-voting, hold a meeting, before the meeting, give them one more opportunity for e-voting, or else keep e-voting machine in the meeting itself, let them go and do it, and then come and sit in the meeting, you talk, they will talk, have jangri mixture, go home. E-voting will be there, count the results, announce it, that's all. Okay. Combining is not possible. I don't know what you are trying to ask. Anyway, what is the meaning of not earlier than 3 months, but at least 14 days? I was giving the reason, you are not listening. Sir, you want to appoint a person other than the retiring auditor. You will not know when I will hold my AGM. So what you will do, assuming that I will hold it somewhere between August 15th to September 30th, you will deposit it in July, which is within 3 months. But you cannot deposit it in March for AGM. So you should plan in such a way that you will deposit it, at least the gap should not be more than 3 months. Before 3 months, you cannot deposit it. Similarly, if the resolution, the notice has already come to you, then at least 14 days before the date of the meeting, you have to. See, you will be getting it 21 clear days before the meeting, right? So you want to know, appoint a person other than the retiring auditor or remove your director. Chalo. Now immediately you send a requisition. Suppose provided the requisite number is there. That should reach the company 14 days before the meeting. Then of course the company has a duty. Once the company gets the notice, it should give its members notice of the resolution at least 7 days before the meeting. See, suppose you have deposited well in time, that is earlier than 3 months, but before the meeting itself, notice itself. Then intelligently what they will do, they will include it in the notice itself. In the notice itself, they will say, appointment of auditor and fixing the remuneration. Resolve that Mr. Donkey B and his CRB reappointed as auditor, Donkey and Associates be reappointed as auditors of the company to hold office for a period of 5 years, till blah, 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 blah. Okay. Then they will also give, incidentally, we have received a requisition from some members requesting that Mr. Donkey may not be appointed, expressly resolving that Donkey may not be appointed. For information, here is the explanatory statement, everything given. That's all. Okay. So that is also possible. But if he is giving it 14 days before, then this requisition should be separately circulated to all the members at least 7 days, exclusive of the day of dispatch of notice and day of meeting. Do you remember? In the same manner as it gives notice of any general meeting, where it is not practicable. See, he is giving it 14 days before. I have to know, prepare, post and send it. It's not practicable. Then notice may be published at least 7 days before the meeting, exclusive of the day of publication of the notice and day of the meeting in 2 newspapers, one in English and one in vernacular. Right? Matters requiring special notice, I already told you. Appointing a person other than the retiring auditor at an AGM, we saw that section 140 subsection 4. Removal of a director, appointment of a director in the place of the director so removed at that meeting. Okay. So this is generally about special notice. Yeah, 14 clear days and 7 clear days. Clear day means not including date of, they are saying date of dispatch. Earlier it was date of service. So once I put it in post, put it. Here in this case, they are saying date of dispatch. That is, the minute I put it in the post office, my job over. So that day should not be included. After that, you have to count 7 days. Then the meeting day. So in between, there should be 7. Similarly, when I am sending the special notice as a member, I should ensure that the day of dispatch should not be taken and the day of meeting in between 14 clear days should be there. Okay. Correct, sir. All the months of 20 must be correct. So I hope I have explained that to you, Vedant Varaji. Chalo. Now moving on from these sections, we go to another simple section and a very, very important form. Company secretaries love the form. If you wake him up in the night and say something, form number MGT 14, like that he will say. Anything they'll say form MGT 14, MGT 14. You just ask him, sir, what is the procedure, sir, form MGT 14? Immediately form MGT 14. Yo, give me the procedure, man, then we'll file your form and all that. Resolutions and agreements to be filed, section 117. Certain resolutions and agreements, together with the explanatory statement, if any, to be annexed to the notice. When? Within 30 days of the passing or making of the agreement, and in the case of IFSC or public or private company, the time limit is 60 days. Sir, IFSC given some liberty, ma, that's all. Don't break your head with this IFSC. IFSC is given some limited liberty. You give it within 60 days. The rest of the fellows will give it in 30 days. That's all. So, MGT 14 should be filed within 30 days of passing or of certain resolutions and certain agreements. What are these things? One, special resolution should be filed. Whenever you pass a special resolution, within 30 days, you have to file MGT 14. Resolutions which have been agreed to by all the members, but which if not so agreed to would have been the effect of passed a special resolution. So, if the Act requires it to be a special resolution, but it has been unanimously agreed, still you have to file MGT 14. You cannot say, we passed it as a unanimous resolution. No. If it is one that requires special resolution, then you have to file MGT 14. Resolutions or agreements which have been agreed to by any class of members, but which if not so agreed to would have been effective for their purpose unless they have been passed by a specific majority. And all resolutions or agreements which effectively bind such class. So, special resolutions or resolutions similar to special resolutions agreed to by any class of members, not all the members, class. For example, if there is any compromise or arrangement, that would come in this category. It's a special majority, but it will not be agreed to by all the members, only that class. That has to be filed. Any board resolution relating to all board resolutions need not be informed. Only board resolution or agreement executed by a company relating to the appointment, reappointment or renewal of appointment or variations of terms of appointment of managing director. Appointment, reappointment, renewal of appointment or variation of the terms and appointment of a managing director. Resolutions requiring a company to be wound up voluntarily, which is passed in pursuance of section 59 of the IBC. Okay, I'm sure you are familiar with IBC. So, in the insolvency and bankruptcy. So, those resolutions, you have to file MGT 14. See, what happens when I file MGT 14? It becomes a public document. So, everybody knows about it. That is why they say file MGT 14. That's all. Nothing else. Once I file MGT 14, it becomes a public document. Okay. Board resolutions passed in pursuance of section 179(3). These are resolutions and important financial and strategic matters which can be passed by the board only at a board meeting. See, 179(3) gives certain 9 or 11 matters which can be passed only at a board meeting. You will not be able to understand this now. When you come to final, we will teach you 179(3). To understand 179(3), I have to teach you 2 earlier sections. And we have to talk about what is a board meeting, passing of resolutions by circulation, at a board meeting, all that. So don't break your little head. Just remember that board resolutions which are passed under section 179(3), board resolutions which are of financial and strategic issues like buyback, authorizing a buyback, issuing of shares, etc. All these things will come. Okay. Normally, resolutions filed under section 117 are public domain and can be inspected, and copies may be obtained under section 399. But resolutions filed under this category cannot be so inspected. When you are filing 179(3) resolution, that case alone, in all these cases, it becomes public. But this part alone, listen to me, this alone will not be available for inspection by public. Kyun? Because it is pertaining to strategy and finance. So it's a confidential. Then why am I asking you to file? So that the MCA will know. So that the regional director will know what you're doing, whether it is as per the law and all. In order to find out if you have violated any section, we want this. But it won't be available to the public for inspection. For example, if you have passed a resolution for going for a buyback, price sensitive, yeah? It won't be made available to the public. Only this. The rest of it is public. Exception to above. Board resolution passed by the following companies. See, exception to above. Only this. What are they? Any resolution for giving guarantee or providing security or loans, etc. by a banking company, non-banking finance, housing finance. In these three cases, you need not file MGT 14. Okay. Similarly, the above, this particular provision does not apply to private company and a specified IFSC. Only this 179(3) category. All other categories, general. This fellow alone, not allowed for inspection in the following cases, for loans, guarantees, etc. by these category of companies, no need. Private IFSC company, no need. Private company and a specified IFSC public company, no need. Any other resolution as may be prescribed and placed in the public domain. As of now, nothing. Okay. A copy of every resolution which has the effect of altering the articles and the copy of every agreement referred to above shall be embodied in or annexed to every copy of the articles issued after passing of the resolution. Suppose you have amended your articles, you have to pass a special resolution. So that resolution or agreement which has the effect of altering the articles should be embodied, means included or annexed to every copy of articles. If you do not file it, then fine of up to 10,000 rupees. In the case of continuing default, why? Because you should have filed it within the 30 days. On the expiry of 30th day, from the 31st day onwards, each day after the first, you have to pay 100 rupees, up to 2 lakh. For not filing it on the 30th day, 10,000. Next day onwards, for every day, 100 rupees, up to 2 lakhs. So this is company, every officer also 10,000. Here the upper limit is 50,000. Here it is 2 lakhs. There it is 50,000. Sir, main agreement is with the MD, sir. Only this is the only agreement. No other agreement. Agreement with the MD for reappointment, etc. That is the only agreement. Rest of it is all resolution, special resolution, resolution. This is the only agreement. Other than that, no agreements. Okay? Only one agreement. See here, only one agreement executed by a company relating to the appointment or reappointment or renewal of appointment. Okay? Got it? So don't break your head on that. Again, in this example, even honestly, I'm not able to get any example. Since you are asking me, I'm telling openly. If I know some example, I'll give you immediately. Mr. Parsadi, I think who's asking this? Manoj Kumar Thakur. If I know some example, I'll give you. I am not able to think of an agreement which has the effect of altering the articles, unless it is a joint venture agreement. But then that, if you are going to file it, where you'll do it? Because here is a resolution, special resolution. But this is again, see, resolution or agreement which has been agreed to by. Okay, suppose we are going for a compromise or arrangement. There could be an agreement. That agreement also has to be filed. If that agreement has the effect of altering the articles, then you have to. I'm not able to think of anything offhand. Okay, don't confuse. It's a very, very straightforward. In fact, most of the items that we discussed are not relevant. Only this fellow is relevant. Special resolution and 179. That's all. The rest of it, rarely you will have in your life. You can be the CFO of a company for up to retirement. You might have filed only for special resolution MGT 14. Yeah, I have checked up with many company secretaries. Rarely they will file under other categories. Maybe this MD appointment, that too once in a while. Not always, not every year. Can statutory auditor ask to see the resolution pertaining to Mr. Manoj Kumar Thakur? I can ask him for his underwear size and he has to tell me, I am the auditor. Why only financial and strategic matters? I have every right to ask any question pertaining to the business. Why only financial and strategic matters? I'm just joking about underwear size. I have not asked it. But I am the auditor. I have every right to ask any question I want. You have to answer it. If it pertains to your business, jolly well come and give me the data and go. Because I have to express an opinion on your financial statements, which include, for example, factory records. I can come and inspect everything. Nothing is a secret for me. Why? I have signed a non-confidential agreement. Yeah. One thing they can insist. What is that? And which many companies do. They can say, look here, you are a chartered accountant. You are bound by your code of conduct. You have signed an NDA with me, non-disclosure agreement. So I know I'm safe with you. But your article clerk, I cannot guarantee, no. Because he is not signed, he is not a member of the institute. He is not bound by the code of conduct. So they may say, see, this is something many companies have told. Either the partner should come and inspect minutes of the meetings. See, many companies will not give the minutes of board meeting and these resolutions copies to non-qualified employees or partners. Only partners and qualified employee assistants will be entitled to see these resolutions. That condition can be. But once I designate my qualified assistant and say he is the senior manager in charge for the audit, he is a member of the institute, proof is given, I would have already taken an NDA from him. Okay. And my NDA will be there with the company. The firm NDA will be there. NDA means non-disclosure agreement. That is, anything I come to know in the course of my audit, I will not disclose to anybody. When big exception is government. I can inform to the government if I'm summoned and asked to give evidence under oath, sorry, my NDA goes. Because I cannot perjure. I will have to tell what I saw. Again, the government also will not reveal it to anybody. It is for some other purpose, for taxation or the criminal inquiry, whatever it is. I will have to cooperate. There I cannot go and say, I am a chartered accountant, I am bound by NDA and all. Even if you beat me, I won't tell you. He will beat. So I won't wait for that. I will give him. Other than that, I can do it. Okay. So this is how it is. Since you asked me, I'm telling. So. Minutes are, but one thing, minutes are very, very important documents. And I already told you now, minutes, if correctly maintained, are evidence in a court of law. Once the chairman of the meeting signs it, it becomes conclusive evidence of what was transacted in the meeting. That is why minutes are very, very important. Company shall cause minutes of the proceedings of every general meeting of any class of shareholders or creditors and every resolution passed by postal ballot, because for postal ballot, there is no meeting. So you should have minutes, like you should say, postal ballots are sent on such and such a day. So many were received, for, against, result was announced. That has to be recorded and kept. Of course, general meeting minutes will be there. Any meeting of class of shareholders, creditors, every board meeting minutes should be there. Committee of the board minutes should be there. Minutes should be prepared and signed in the prescribed manner in books kept for that purpose with their pages consecutively numbered so that you cannot tear one page in the middle and go. When should it be updated? Within 30 days of the conclusion of every such meeting concerned or passing of resolution by postal ballot. The minutes should be updated within 30 days. Exception. Minutes of the proceedings of board meeting of or committee of a specified IFSC private or public to be prepared and signed in the manner as may be prescribed before the next board or committee meeting. So normally when you come to final, you will learn the gap between two board meetings can be more than 4 months also you can have. So then when the gap is there, once the next meeting, it is enough if you maintain it. Okay. So Section 118 minutes shall not apply to Section 8 company as a whole, except that minutes may be recorded within 30 days of the conclusion in the case of companies where the articles of association provide for confirmation of minutes to circulation. See, a Section 8 company also, though it is exempted, they will maintain minutes because minutes are statutory, no doubt, prescribed under 118. They are also very important documents. They record decisions. They become solid evidence. So it has to be maintained. Minutes are the record and evidence of the business transacted in the meeting. No meeting is concluded until the minutes have been properly recorded and signed off. The minutes of each meeting shall contain a fair and correct summary of the proceedings. Fair and correct. Okay. All appointments made at any of the meetings aforesaid shall be included in the minutes of the meeting. This is rule 25. Okay. All minutes book shall be maintained. A distinct minute book shall be maintained for each type of meeting. General meeting, meeting of creditor, meeting of board, meeting of committee, separate. The minutes of the proceedings of each meeting shall be entered in the books maintained for that purpose, along with the date of such entry within 30 days of the conclusion of the meeting. See, beauty of Companies Act, no, they will say it in the section, again they will say it in the rule, they keep on saying it, here also they will say, there also they will say, 100 times you have to remember, that's all. Basically, minutes should be updated within 30 days. A brief report of the postal ballot should also be entered within 30 days. It's not a big thing. The minute books of general meetings board shall be kept at the registered office of the company and shall be preserved permanently and kept in the custody of the company secretary or any director. Custody means you can't take it home. The lock, it will be in the secretarial department in a safe locker or something. Key, the key control will be with the company secretary or any director duly authorized by the board. Additionally, the minutes of the board and committee meetings can be kept in a place as the board may decide. Minutes of general meetings, you can hold it only in the registered office, nowhere else. Each page of every such books shall be initialed or signed by the chairman, and the last page or the record of the proceedings or each report in such book shall be dated and signed. Who will sign it? Minutes of the meeting of a board or a committee, chairman of that said meeting or the chairman of the succeeding. Why? Because this man may be the chairman, then he may go, then at least in the next succeeding meeting, you have to get it signed by the chairman of that meeting. Got it? Within 30 days, you maintain it, keep it. If this fellow is there, get it signed. He's gone abroad, he's not going to come back. In the meantime, we have to hold another board meeting. That chairman, you show him. Minutes of the general meeting signed by the chairman of same meeting. Within general meeting, same meeting. The chairman of that meeting should sign within 30 days. In case of any event like death or inability, any director who is authorized by the board can sign it. Okay. The rule followed for minutes of general meeting applies for any resolution passed by postal ballot. So whoever was the chairman announcing the postal ballot, within 30 days, he has to sign the minutes. Matters that shall not be included in the minutes. Any matter which in the opinion of the chairman of the meeting is or could reasonably be regarded as defamatory, is irrelevant or immaterial to the proceedings, is detrimental to the interest of the company. For example, the secretary of the company is a very dutiful gentleman. He writes everything. He writes, in the course of the meeting, Mr. Donkey stood up and shouted at Monkey and said, Monkey, you are a fraud. I can prove that you are a fraud. He showed his hand at him and waved it. Monkey objected to it. Then there was a fight between them and Monkey slapped his left cheek of Donkey. Chalo, it happened, no doubt, but it is detrimental to the interest of the company to record it. So the chairman can say, Mr. Secretary, please don't record all this. In the meantime, Monkey is getting up and telling, no, chairman, minutes are wrong. I didn't slap the left cheek. I slapped the right cheek. Hey, this is irrelevant, yeah. Don't bother. Don't record it. Okay, is the point. You need not be so accurate. What is needed is the crux. What is the resolution? What did you decide? What is the company going to do now? Record it. So that tomorrow, company is an artificial person. People may come, people may go. We should know what was decided and it should be documented. I don't have to call every board meeting, every board reader, what happened on that day, tell me, yeah. No, Donkey told like this, Monkey. You get confused. So if minutes are there, I don't have to go to anybody. I simply refer to the minutes. We know what happened. We know what decision was taken. That is why minutes are to be prepared, signed, recorded and signed. Chairman shall exercise absolute discretion in regard to the inclusion of any matter in the minutes. Matters to be included. The names of the directors present at the meeting. In the case of each resolution, the names of the directors dissenting from, this is for board meetings, dissenting from or not concurring with the resolution. In fact, in many committee meetings, sometimes I find that the decision taken by the committee by majority is not good for the organization in the long run. Therefore, sometimes I will stand up and I will say, Mr. Chairman, I am dissenting from the resolution and the fact that I have dissented may kindly be noted. So that is normally what I insist. But here they say, if there is a dissenting, then that has to be clearly indicated. No document pertaining to be a report of the proceedings of any general meeting of a company shall be circulated or advertised at the expense of the company unless it includes the matters required by this section. Meaning, you cannot write some nonsense and call it the minutes of proceedings. It should be statutorily kept and then you can circulate it. Nothing. Proceeds of general meeting can be sent. Proceedings can be sent. Every company shall observe the secretarial standards with respect to general board meetings prescribed by the ICSI, our friends, Institute of Company Secretaries, and approved as such by the central government. This provision does not apply to IFSC public and private companies. So, minutes shall be evidence of the proceedings recorded therein. I already told you. Where the minutes have been kept in accordance with this section, then until the contrary is proved, the meeting shall be deemed to have been duly called and held, all proceedings to have taken place, resolution passed by postal ballot to have been duly passed. All appointments of directors, KMP, auditors, company secretary shall be deemed to be valid. Unless contrary is proved. Be careful. Proving it is a totally different. You have to really prove. Because the minutes will be conclusive. You have to prove by so many methods. Very difficult. That is why minutes properly maintained are more than enough. Court will not so easily ignore the minutes. In case of default in compliance with this provision, company has to pay penalty of 25,000 rupees. Officer 5,000 rupees penalty. Penalty for tampering with the minutes. It's a criminal offense. Where already minutes have been correctly maintained, you tamper with it. You do some nonsense, like you means not you. Some fraudulent fellow does, slowly using blade and removing, then just changing the initial. Some nonsense. If you tamper with the minutes, imprisonment, 2 years and fine 25,000 up to 1 lakh. Any person found guilty of tampering. Not necessarily officer. It could be even an employee. If you're tampering, gone. See, you'll be very surprised. In the Companies Act 1956, the penalty for non-maintaining minutes with respect to any meeting, please note, I just come back for that purpose only. Default in compliance with any of the provisions of section 118 and the relevant rules relating to minutes, maintenance of minutes with respect to any meeting. Meaning what? Every meeting, if you don't maintain minutes, per meeting 25,000 rupees. Per meeting 25,000 rupees. Huge penalty. In the law was amended. In the 99 amendment, it became 5,000 rupees. I'll tell you there's a small anecdote. I don't want to. It's a very, very confidential thing, but I'll tell you without names. See, in 1994, 95 and all, 95, 96, there was a huge boom for public issues. At that time, you may not have, I don't know if you're born, some of you may not have been born also, but that time I just qualified as a company secretary, practicing chartered accountant, somehow trying to make a life for myself, teaching, struggling hard to grow in my life, etc., etc. So I needed money. So since I am also a company secretary, I used to do secretarial consulting. And at that time, our friends, the practicing company secretary, were not present. They were still coming. Nobody was there to do all this. So there was need. So when a qualified chartered accountant who also as a company secretary was available, they hired me. So I used to prepare the minutes books and I used to do everything, whatever thing. So, and I used to charge them bulk. So in those days, 50,000, 25,000 totally, including prospectus vetting. I will go along with the merchant banker to the SEBI, to the ROC, ensure that the prospectus is registered. You remember? Prospectus is registered. And so once I did it, the registrar of companies, I knew him well. He's no more. He's a great human being. Another teacher of mine. And when he saw me, he said, Srikanth, come. What is it? Certain prospectus, sir. Because I had told the merchant banker, because they were going for the public issue, SEBI had already cleared it. Only condition, get the prospectus registered, come release it, issue it. So everything is ready. So they all thought, I also thought it would be normally done. So everything is correct. We have vetted, he got it, everything is correct. Suddenly he went through the prospectus and he looked at one line. He said, Srikanth, here it says that there is an agreement between the MD and in his proprietary concern and the company for sale of some land. What is this about? I said, yes, sir. The MD has sold that. It has been disclosed, etc., sir. And was it approved at the board meeting? Because it has to be approved at the board meeting. You will see that when you come to final duties of directors and powers of directors, 188 related party transaction, you'll see that. Yes, sir, he has disclosed. No, has he disclosed it in the board meeting? Like that, yes. Sir, yes, sir, it has been done, sir. Like that, I told. I'm going to maintain the minutes later. Nothing is ready at that time. Sorry, the minutes were not ready. But I knew I can go home, sit in the night, finish it off and keep it ready. He said, Srikanth, I want to see the minutes book. He said, sir, what, sir? I am your, yeah. Since you are so saying that you are teacher of company law, knowledgeable, blah, blah, you should know. Show me the minutes book. I said, sir, minutes book and all, we have to go and get it. It's too very far away. What far away? Where is the office? Mylapur. The ROC is in Nungambakam. Mylapur. Hey, Mylapur, na, you wait. Go and bring the minutes book. Minutes book is not there. I have not written it. I've got the notes and all ready. Beautifully, I have prepared the structure. All I need to do is record it. Get it signed by the chairman. I'll keep it. It's all book meetings. I was not looking at it. Then I remembered that while teaching minutes, I had remembered. Then I stood up and I said, sir, wait, sir. I took my purse. Took my purse out. And at that time, no 500 rupee note. No, there was a 500 rupee. At that time also, I took out a 500 rupee note and I gave it to him. Yes, sir, please have it. What do you mean, Srikanth? What are you trying to do? No, sir. This is the fine for not maintaining minutes, sir. I have not maintained the minutes of that meeting, sir. Penalty 500 rupees, sir. I paid, sir. The day after tomorrow, I'll come, sir. In the meantime, you clear the prospectus. He started laughing. He said, Srikanth, what are you saying? Yeah, please take the section, sir. He took the section. He said, $500. That's all penalty. Absolutely, sir. Please give me a receipt. Sir, please, in the meantime, kindly clear the prospectus. He started laughing. He said, what is this, Srikanth, like that? And then, sir, what to do, sir? That is your law, not my law. Okay. Then he laughed and then he cleared the prospectus, etc. Then he said, I warn you, please produce the minutes to me tomorrow. That night, I burnt midnight oil. I prepared everything. Next day, I dutifully took it to him, showed it. He inspected, sir, good show, go. Matter over. But he got so angry. Then later on, when he got the opportunity, he was on the panel for amending the law. Huge amendments in 99. One of the amendment was this section he amended and he made it 5,000 rupees for every meeting. Then, so even later on when I met him, he said, Srikanth, now 5,000. But sir, I said, 1,000 rupee note has come, sir. 5 notes are enough for me. It's only keeping track with inflation. Then now in the 2013 Act, they made it really tough. 25,000. So not maintaining minutes is going to be a little thing. Sorry for this very elaborate anecdote. Sometimes, when you are an old man, more than your wealth, it is your memories that are precious. So I thought I will share it with you. Just a story that it happened. It happened in real 95, I think 94 or 95. I don't want to tell the name of the company and all. Okay. The book containing the minutes of the proceedings of any general meeting of the company shall be kept at the registered office of the company and be open for inspection during business hours by any member without charge, subject to such reasonable restrictions. However, it should be open for at least 2 hours in each business day. You can impose reasonable restrictions, but at least 2 hours you should give. Any member shall be entitled to be furnished within 7 working days after he has made the request on payment of such fees with a copy of the minutes. If you don't give them the copy or allow inspection, penalty 25,000, 5,000. Tribunal can also direct immediate inspection of the minutes books. And immediately you have to give it. In case you don't, it's an offense. Any member shall be entitled to be furnished within 7 days after he has made a request of the company of the copy of any minutes. He can be charged some reasonable amount, not exceeding 10 rupees for every page. Okay. A member who has made a request or provision of soft copy of any meeting should be furnished the same free of cost. Every listed company having at least 1,000 shareholders may maintain its records as required in the electronic form. Okay. The MD company secretary shall be responsible. Usually they will maintain it on a software. Okay. In fact, there should be some controls also for it. And we have to see that security is there. Highest security, especially the register of members and the register of debenture holders. We have to be very careful. We'll be seeing the registers in the next 1 hour. I'll teach the registers. So These records should also be made available for inspection. Copies also can be given. This is very important because many of these sections, 98 to 100 to 111, 100 to 111, if you apply it to the OPC, it will result in absurdity. There's one man, what quorum, what blah, blah, blah. So 122 says, provisions of section 98 and section 100 to 111 shall not apply to OPC. Any business which is required to be transacted at an AGM or other meeting by OPC by means of an ordinary or special resolution is sufficient. Okay. If the resolution is communicated by the member to the company and entered in the minutes book, that is all, because it's after all one member. That member communicates in writing, it is entered in the minutes book, decision taken. Signed and dated by the member, such date shall be deemed to be the date of the meeting. So one person meeting, you can say. Where there is only one director of the board of director of OPC, any business required to be transacted meeting of board, it shall be sufficient. If that OPC, the resolution by such director is entered, signed and dated by the director, shall be deemed to be passed in the board meeting. Right? Now, so topic is not over yet. We still have members' registers. You remember, I only completed meetings. You still have registers. So I need to go there. But before I do that, I'll just open it and keep it ready. Registers and returns. Before I do that, let's have a small break. Let's have a small break. Now the time is 7:37. Okay. 7:45, 7:50. 7:45 to 7:50 max. Between 7:45 and 7:50, we will assemble back. Okay. Welcome back from your much needed break. The idea was just to give you a small breather. Continuously, we have been discussing little dry as it goes. Slightly meetings will become a little dry. From now on, registers and returns, purely theoretical part. And just give me 1 minute. Yeah, very, very theoretical. So I may push in case I'm not able to complete it today. Tomorrow morning, we have a class. Tomorrow, I'm taking 2 sessions, morning one and evening one. Because 21st I didn't take. Therefore, I'm taking tomorrow morning one and evening one. Mostly, if I don't complete this topic today, tomorrow I'll finish it. Some leftover portion, I'll finish it. And then we'll take up general classes tomorrow. Maybe finish it tomorrow if possible. Otherwise, Monday. Then take up negotiable instruments. Go on. 30th, inshallah, 31st, we'll finish negotiable instruments and be happy. Some questions have been raised by some of you. Mr. Narayan Nagarajan wants to know what kind of resolutions are to be mandatorily filed with MCA. Sir, I already told you, I can't go back to that slide. I will be uploading it possibly tomorrow or maximum Monday. When you go through that section again, special resolution, all that I gave a list now. They are all mandatory to be filed with MCA. Let's go through that list. I already gone through it. I don't know, maybe you missed what I said. So that list is the kind of resolutions to be mandatorily filed with MCA. That MGD 14. Got it? Even copies of the minutes are to be. Manoj Kumar Thakur wants to know. No, sir. See, books of account only you can destroy within 8 years and all that stuff. Minutes for lifetime, you have to maintain it. In fact, I've seen minutes of companies 100-year-old and all. 50-year-old minutes. Minutes are to be kept lifetime of the company. Finally, after winding up, maybe you can destroy it. So it can be destroyed. Lifetime. Books of account is 8 years you can. Minutes are maintained as book or electronic. Mr. Bharsarthi is asking. Chinmoy Das is jumping in and saying both. Where he gets the idea, I do not know. See, minutes are to be signed by the chairman of that meeting or the next meeting, board. Okay, so or that meeting. So sign cannot be done in electronic form. It has to be maintained in physical form. It can be maintained in physical form as a book. Ideally, you should write it. But if you want to print it on sheet of paper in digital way, you can. But at the end of every year, you have to collect all that and bind it together, serially number the pages. It should be kept in bound form. The minutes are to be bound together. But it should be in writing only, in document form, signed. You cannot have it in electronic. That is soft copy. You cannot have it in digital form and say that is the minutes. What is the proof? Signing is important. No? For that, you have to print it. So, Chinmay Das, don't jump in with answers. Unless you want to take over as faculty, then I will stop. You take. I will stop. I will stop. What do you say? You come and conduct the class. Not yet. We have not got digital maintenance of minutes yet. You can see what you can do. You can enter it in Word and then you can print it out and get it signed by the chairman and all. But it should be serially numbered. Pages should be serially numbered and it should be bound at the end of the year and kept safely. I don't know what it is here. 6 audit session. Sorry, putting such audit words. I don't know. Chalo, no problem. This is incidentally company law, corporate and other law session. Batch 6. I am Srikanth. I am the teacher of company law. I am teaching company law. I see in Chennai, I was teaching in the SARC, Southern India Regional Council. Those days, when I was a teacher starting my career, SARC invited me because I was regular faculty for ICSI. They said, you also come and take for us. I'll do that. My alma mater, I will take with happiness. I used to go. Huge hall in Nungambakam. Southern India Regional Council, we have 5 or 6 huge halls where we conduct classes for students. At a time, 100, 200, 300 students will sit. Mic will be given and we will take. It's a huge class. And there are some classes in those days in Brahmaya Hall where The entire room will be full. 800 people will be sitting. And some very popular faculty like Mr. C.R. Bhupati, C.R. Shivakumar and all will be taking classes in those days. Okay, in the institute. So I used to take company law and some 200 or 200 people will be there. Once I started teaching accounts, like the topic, accounts and audit, accounts topic, what I taught you. I was teaching it. I was teaching and about half an hour in between, suddenly 2 or 3 people in the last 2 rows, they stood up and started walking out. I was worried. Hey, what are you doing, man? What happened? Did I say something wrong? What is it? Why are you going? Is it so boring like that? I said, no, sir. We thought we are attending accountancy class. Fellow does not know. Accountancy class is going on in the 2nd floor. See, imagine this fellow sat in the wrong class for half an hour. Possibly because accounts are something like that, related accounts, something, maybe charges, something. Fellow must have been wondering when this fellow will teach double entry, when this fellow will start teaching journal entry like that, he'll be worrying. And I never came to journal entry. I was keeping on going into section. Maybe my friend Chinmay Das is also having similar problems. I don't know, yeah. It doesn't matter. I'm only saying don't give answers. Allow me to give the answer. Okay. Registers are very, very important. We are now going to talk about that. Pure theory, not relevant from exam point of view. I am covering only because it is there in the syllabus. I am covering it. Not important from exam point of view. Don't break your head on it. Okay, I will break my head. Please break your head. Who can prevent you? Okay, have bare knowledge about it. Don't go ignorant. Read through it and go. Don't have to be depth knowledge in this. Section 88, Register of Members. Okay, this is an important register. These are called statutory registers. Very important. Section 88, Register of Members. Register of Members, Rule 3. The format is given in Form MGT 1. Register of Debenture Holders or any other security holder. Rule 4. Format given in Form MGT 2. That format you have to use. Maintenance of Register of Members, etc. Rule 5. Index of names of members, Rule 6. Foreign Register, Rule 7. Section 89. Declaration of beneficial interest in respect of beneficial interest in any share. Declaration in respect of, IRO means in respect of beneficial interest in any share. See, when you are not, your name is not mentioned, but you are having beneficial interest, then you should mention it, that I am the beneficial owner of these shares. Okay, Rule 9, Form MGT 4, MGT 5, MGT 6. Section 90 is the register of significant beneficial owners. So when shares are not held in the name of the beneficial owner, you should have a register of significant beneficial owners. 91, power to close register of members or debenture holders or other security holders. How to close for a certain period. It's called closure of books. We talk about that. So 88, register of members. Every company should maintain a register of members in MGT 1. See, remember 88, I skipped it. I went directly to 97. That is why I'm going back to 88 now and teaching. So if you are religiously following Board of Studies materials, you have to go to the beginning. There you will find this is there. So suddenly you will find your Board of Studies material has come to an end and this fellow is not taught these sections. Sir, what to do, sir? Don't worry, I will teach. Now going to go teach. Go back. Okay. So every company to maintain register of members in Form MGT 1 from the date of registration. The holding of each class of equity and preference shares by each member residing in or outside India to be shown separately in the register of members. Register to be updated within 7 days of the date of approval by the board or committee thereof. So the minute it is allotted or the transfer is approved, it has to be entered within 7 days. Possibly the only important data for you is 7 days. Updation should be done within 7 days. Register of members. Register should be entered in the registered office. But if a special resolution is passed, the register of members may be kept in any other place within the city, town or village in which the registered office is situated, or in any other place in India in which more than 1/10 of the total members are entered or registered of members reside. Of course, if you are a listed company, you can have electronic register. register of members can be maintained in electronic form. We'll be seeing that. In which case, you will have an outsourced service provider who will maintain it on a cloud platform. So that your company will have access on cloud. So your company secretary or secretary department will have access to the register of members on cloud. It will be updated by the share transfer agent, who will get the information from the DP and the depositories. So every day when the transactions are happening, depository will dump to a special server in the register of transfer register with a share transfer agent. So that will come. Any other transfers, if you are getting off-market transfers, you will send it rare. And that will all be collated by the share transfer agents. Daily register of members will be updated and on cloud. So next day, if you go, you will see updated register of members like that. So today, most listed companies and companies having more than 1,000 shareholders, they maintain in electronic form. Register of members can be maintained in electronic form. Okay. If there is any order of attachment passed by any competent authority, that has to be mentioned in the register of members. If there is any charge, a lien, pledge, suppose the shares have been pledged for financing or hypothecated, then that also should be marked in the register of members. Of course, the shares will also be appearing in the DP now from the member side. The DP will also mark the pledge or lien. The register of members also should mark the pledge or lien. The particulars to be entered: name and address of the member, date of becoming member, date of cessation, amount of guarantee, if any other interest, if any. See, in the case of a company not having share capital, limited by guarantee, you should mention the amount of guarantee. In the case of company having share capital, shares will be mentioned. Okay. Also, you have to give all the KYC data, na? Permanent account number or corporate ID number, permanent account number, nationality. In the number is the minor, name of the guardian. Member cannot be a minor, can be a member. But see, normally it's entering into a contract. But minor can be a member, but he cannot vote. Only the guardian will vote till he attains majority. Register of members. Every company which issues or allots debentures shall maintain register of debenture holders, MGT2. Any change in the status of members occurring in the member or debenture holder, etc., should be updated, entered in the respective register explaining the change. Okay. Also, it should have an index of names. You see, once you have more than 1,000 members, if you are maintaining in physical form, you may be maintaining folios for members. So you will be maintaining folios on the basis of when he became a member. So it will not be in alphabetical order. Therefore, there should be a separate index in which you have to enter in alphabetical order and give the page number in the register of members. All this is needed only when you are doing it in manual form. But if you are going to do it in electronic form, no need. Because just have to search, give the unique registered folio number or whatever it is, or name of the member, immediately you will get. Okay. So this is important. Where the number of members is less than 50, no need for index. Foreign register. See, where the company has a share capital or which has issued debentures or any other security, if it has foreign shareholders, it can keep the register of members in any country outside India with respect to those security holders, foreign security holders, who are resident, beneficial owners resident in that country. This will be taken as foreign register. Foreign register is optional. If you want to maintain, maintain. If you don't want to maintain, maintain in India. If they want to maintain, maintain. Suppose you are having a lot of foreign investors. All are in Los Angeles, Silicon Valley. So they maintain foreign register also. What is that? The company shall within 30 days from the date of opening of any foreign register, file with the ROC notice, giving the situation form number MGT3. Any change should also be informed within 30 days in form number MGT3. Foreign register shall be deemed to be part of the company's principal register of members, and the foreign register shall be maintained in the same format as the principal register. Entries in the foreign register shall be made by the board of directors or its duly constituted committee after the board approves it or the committee approves it, as the case may be, the company may discontinue the keeping of any foreign registers. So that all entries in the register will be transferred either to some other foreign register or to the Indian register. That is the principal register. A copy of every entry in any foreign register should be transferred to India within 15 days. See, the idea is any transaction between two foreigners will be updated in the foreign register. But within 15 days, it has to be updated in the principal register also. And a duplicate register, there should be a duplicate here which should be updated. So, foreign register, duplicate will be in India. No transaction with respect to any shares, debentures or any other security registered in a foreign register shall, during the continuance of foreign register, be registered in any other register. So, idea is simple. You have, say, 2,000 shareholders in Los Angeles or, as I said, California, in wherever you are, and you feel that is necessary, you have a register there and update it there. Only for the foreigners, that is the citizens of the United States of America. Penalty for failure, non-maintaining registers of members, debenture holders, etc. 3 lakhs for company and 50,000 for officer. See, if in case you have not maintained the register of members, you can compound it. What is this compounding and all? Don't waste your time. It is not in your syllabus. That is, instead of getting convicted, you can pay a penalty. You can pay a compounding fee and they will say you are not convicted. You are not guilty. But for that, you have to pay compounding fee. But that is possible for this offense. Okay. So if there is any nomination, suppose you are a member and you are nominating somebody, nominee is there, that also should be entered in the register. Entries in the register under 88 and index should be authenticated by the company secretary. That is, after the entry is made, it should be authenticated by the company secretary by affixing the signature. But in electronic form, if you are maintaining, all this is not there. Where shares are held in the name of a minor, the name and details of the minor's guardian shall be entered in the register. Mr. and Mrs. and Mr. Taneja recently got married and jointly purchased the shares of New Hopes India Private Limited on 14th August 2018. Mr. Taneja intimated the company that only the name of his wife should appear in the records of the company for the shares purchased by them. Is this possible? No. Both have to be maintained. You have to mention everything. You can't say only wife. If then you register only the name of the wife. Everybody. If there are more than one member, then all the members' names should be entered. No question of only wife. Okay. Joint holders of shares may request company to enter their names in certain order or execute transfers to have their holding split, with the result that part of the holding is entered showing the name of one holder another. However, the condition of Mr. Taneja that only the name of the wife should appear cannot be catered to. I told you already. Although the names can be entered in the order such that the wife comes first. The reason for that, articles of most companies provide, in the case of exclusion of other joint holders, seniority shall be determined by the order in which the names stand. So, you can't only put wife. Taneja, maybe Mr. Taneja is such a humble husband, he is obeying his wife so much, he doesn't want his name also to come. What a great husband. But sorry, name should be mentioned. Sir, index of names, now, suppose, see, the register of members will be maintained in chronological order. Then how to locate the name of a member? So another index will be there. Telephone index is there now. It will be in alphabetical order, right? Then the page number where the entry is there, you will have it. So if you want to look for, say, Parthasarathi, I will look for it in P. There I will see Parthasarathi, yes. Then I will say folio number 46. I will go to 46, which will be your folio. That will be there in the index. Using the index, I will locate your registered folio. It's called index. But if it is in electronic form, no need for index. Because you can search now. By drop-down menu, you can search. But in those days when manual was there, so think about it. Even if you are maintaining a telephone book, you will have an index now. In the corner, you will have A, B, C, D. Using that, you will go there, right? Like that. Index of names. A company which has share capital or which has issued debentures or any other security. I'm sorry. Foreign register, I think we have finished it. Sorry. Moving on. Tonnage over. So, beneficial interest. What? Simple, sir. In this country, people buy assets, but they don't have source. They don't have money. They don't have white money. So they transfer it to some relatives who hold the shares. They are called binami. Okay, binami means a person who is not the owner, but whose name is mentioned as the owner. Who is the real owner? That is the beneficial interest. So a member not holding beneficial interest in the company, if he is a binami, then he has to inform. He has to declare in form number MGT4 within a period of 30 days from the date on which his name is entered in the register of members. He should declare, I am not the beneficial owner. That's all. He will not say I am a benami. He should say I am not the beneficial owner of these shares. That's all. Any person holding beneficial interest in the shares in the company should mention that he is the person having beneficial interest. So there will be a separate register of beneficial owners, which will be maintained. So any changes in the beneficial interest also should be maintained within 30 days of the change. Where any declaration under this section is made to company, the company shall make a note of such declaration in the register concerned and shall file within 30 days from the date of receipt with the registrar in form number MGT6. But there is one legitimate example of how there can be entry in this register, which is not something wrong. I gave that example yesterday. Jnanesh Ingle was asking the question. That is wholly owned subsidiary. Holding company is the only shareholder. But we need 2 or 7 as the case may be. What to do? So I told you, 1 share will be transferred to 1 person or 6 shares will be transferred. They will be nominees. They will not be beneficial owner. So they should make a declaration. I am not the beneficial owner. I am holding only as an nominee of company, which is this holding company. That's all. So that the company will declare I am the beneficial owner. So allowed under the Act. Consequence of non-filing. Okay, then where a declaration is not filed, any right with respect to such shares shall not be enforceable by the beneficial owner. Later on, you cannot come and say, no, I am the beneficial owner. Sorry. You should have informed at that time. So this fellow is a beneficial owner like that. Okay. That is a problem. Trust which is created or set up to exemption, of course, is a trust which is set up for a mutual fund. Obviously, they are not holding it their own name. They are holding it only as a trust for the unit holders. So that is exempted. Okay. Nothing contained in this section shall be deemed to prejudice the obligation of the company to pay dividend to its members. Whosoever name is mentioned, benami or otherwise, he only will be getting the dividend. That's all. Once I have given the money to him, dividend paid. Even though you are told you are the beneficial owner, you go take it from him. That's all. Central government can exempt certain companies from this provision and all that, as usual. In case the declaration is not made, penalty is there, 50,000. In case of continuing offense, 200 up to 5 lakhs. The beneficial is not declared. Failure to file the return by the company, 1,000 per day up to 5 lakhs. Every officer, 1,000 per day up to 2 lakhs. Section 89 will not apply. That is, this benami and all will not apply. Provided they have not, because government company, you cannot have all this. Significant beneficial owner means a person or an individual who acting alone or together or through one or more persons possesses one of the following rights or entitlements in the reporting company. Like holds that indirectly or together with any direct holdings, not less than 10% of the shares. Significant beneficial owner. Holds indirectly or together with any direct. See, direct means in my own name. Indirectly means through benami. Not less than 10% of the voting rights. Has the right to receive or participate. Not less than 10% of the total distributable dividend. See, in all these cases, I will know about it only if he declares. If he does not declare, I will never know about it. Has the right to exercise or actually exercises significant influence or control in any matter other than through direct holdings. See, I told you now, this is all not very important. Don't break your head on small issues. Major provisions we already covered. Syllabus has to be completed. I'm covering this. So, majority stake is also defined. More than 1/2 of the equity, 1/2 of the voting rights. Okay, all that. Direct and these are all defined there because they are used in this section. That is okay. When I'm holding it directly or when I'm holding it through Benami, it becomes an indirect. Okay. Every reporting company shall give notice in form Ben 4 to any person whom the company knows or has reasonable cause to believe to be a significant business beneficial owner. See, you have reasons to believe that these are all Benamis and that fellow is a significant beneficial owner. So you have to give notice. Or you have reason to believe or to be having knowledge of the identity of a significant beneficial owner. So you call the Benamis and say, look here, who is the significant beneficial owner? Please tell us. To have been a significant beneficial owner at any time during the 3 years immediately, then you should give a notice in Ben 4 and should maintain a register of significant beneficial owners in form Ben 3, which shall be open for inspection during business hours, etc. Believe me, these provisions are there. 100% nobody will comply with it. You mean to say they are fool? I have put a Benami for holding. You mean to say I'll come and tell I am the owner? Never. Never it will be done. Why I put the Benami? So that my name should not be known. Will I come and tell? Later on in CBI inquiry, somewhere else in vigilance and all, it will come. That will be a different story. Okay. But they put a duty here. Okay. If the fellow does not give the information, company can apply to the tribunal. And then once the tribunal passes the order, then the fellow has to give the details. See, these are all given just as a matter of protection. So that tomorrow the CBI or government will say, look here, you had the duty to disclose. If the company is trying to play games, they will say, hey, you had the duty to ask why you have not sent Ben 4. Like that. Okay. So every individual who is an SBO, significant beneficial owner, should declare in form Ben 1 within 90 days from such commencement. The reporting company will have to file the said disclosure with the registrar within 30 days. Friends, this procedure will never be complied with. Unless the fellow is a fool, he won't come and do it. Okay. Sorry, the very beautiful section, procedure, etc., but practically useless. Any individual who subsequently becomes SBO in the reporting company or who SBO undergoes change should require to file a declaration within 30 days of acquisition or change. See, I'm not an SBO, but I become an SBO later, inform within 30 days. If an individual becomes SBO in the reporting company or a significant beneficial ownership undergoes any change, then it shall be deemed that such individual became the SBO of or any change therein happened on the date of expiry of 90 days from the date of commencement of said rules. See, this is when these rules came into force. Now they are over. So, contravention, SBO fails to declare initial failure 50,000, continuous failure 1,000 per day. All nonsense. Reporting company fails to file Ben 3, initial failure, continuous failure. Every officer 25,000, 2,000. Contravention by company and officer in default of provisions of section 90 and all. See, this whole thing is, I'm telling you, I'm not trying to say the law is not right, but waste of time for everybody. You for reading, me for teaching, government not, it's there. Nobody is going to give their declaration like this, 100%. Okay, now we go on to 91, which is a company may close the register of members, debenture holders, and other security holders by giving minimum 7 days notice. Why they will close? No, in those days, for payment of dividend, you have to arrive at the correct list of members. So for that purpose, what they will do, they will stop registering transfer. They will say from such and such a time to such and such a time, the register will be closed. So for that, they should give 7 days notice. So that all transfers will be sent before that date. Any transfer sent after that cutoff date, then the register of transfer will happen only after that closure. During book closure, there will be no transfer registered. So in those days, they used to announce transfer book closure and all, we will rush to get the share registered. We will buy the share and not keep it registered so that you can avoid stamping. So we will keep it in the original name with the blank transfer we'll have, which we will, once I sell the share, immediately I'll go and give back the physical certificate. All this was there only when physical certificates are. Today, it is all electronic. Instantaneously, my name will be entered in the register. If the transaction is over, so there is a today, to my knowledge, register is not closed because they are all electronic registers. And if you are maintaining manual register of members, maybe having 600 shareholders, then you may want to close it. Inform members, if you want dividend, send it before this date. After that, we are closing for 10-15 days. You can close for up to 30 days at a time. And totally within 1 year, you can close for 45 days. See, there are companies like MRF which give dividend 4 times in a year. They give quarterly dividend, right? So those days before electronic form, they would have closed their closure of books for 10 days, 10, 40 days they would have done. 4 times they would have done. Can do. If the registers are closed without giving notice or after giving shorter notice, then there will be a penalty of 5,000 for continuous offense and up to 1 lakh. So, you can again compound this offense. Private companies have been exempted from issuing public notice in newspapers. 92, annual return. We kept on talking about it. Financial statement, annual return. Every company shall file its annual return in form number MGT-7. Okay, MGT-14, MGT-7 and all regularly used forms. Every year you have to file MGT-7. Okay, except OPC and small company. OPC and small company shall file an annual return from 2021 onwards, financial year 2021 onwards, in MGT-7A. Every company shall prepare a register containing the particulars regarding registered office, principal business activities, particulars of its holding subsidiary and associate companies, shares, debentures and other securities, and shareholding pattern, its members and debenture holders, along with changes therein, all that as well. Promoters, directors, KMP, any changes during the period, how many meetings were held, or class meetings, board meetings, committee meetings, all that you have to give details. See, the annual return is nothing but what happened during this period. We want to know. That's all. Did you hold board meetings? Did you hold AGM? When did you hold it? Last time? What happened? All that. Remuneration of directors and KMP, penalty and punishment imposed on the company, if any. Matters relating to certification of compliances, disclosures, details as may be prescribed in respect to foreign institutional investors, any other matter. So, annual return has to be signed by a director of the company and the company secretary. Signing here need not be physical because the MGT-7, you can upload it in digital form and you can sign it digitally. And it should also be signed by the company secretary in case there is no company secretary, by a company secretary in practice. MGT-7 needs CS certification. Practicing company secretary should certify if you don't have a company secretary. For OPC and small company, it should be signed by the company secretary, or where there is no company secretary, by the director of the company. Okay. Even an abridged form for OPC may be prescribed, not it. Annual return filed by a listed company having paid up share capital of 10 crore or more, turnover of 50 crore or more, shall be certified by a company secretary in practice. The annual return should be certified by a company secretary in practice. And the certificate shall be in form MGT-8. Okay. For a listed company or a company having 10 crore or more paid up share capital, 50 crore or more turnover. See, this provision earlier was 2 crore. These fellows went and got it raised to 10 crore. And I asked, why are you doing it? Why are you cutting your own throat? They said, no, Mr. Srikanth, this is respectability for us. Up to 10 crore now, company secretary should be there. Only about 10 crore we will give. Something they said. 2 crore you are earning money. You have now increased that limit. Now you are losing that. So, okay, chalo. It must state that the annual return discloses the facts correctly. See, just like chartered accountant is certifying the balance sheet, our company secretary will certify that MGT-8. I mean the MGT-7. The certificate will be in the format of MGT8. Oh, they will make a big fuss for certifying. Financial statement I will certify in one shot and go. They will be taking so long doing this, verifying that. They are so afraid of signing. Every company shall place a copy of the annual return on the website, and the web link should be kept in the board's report. The copy of the annual return shall be filed with ROC within 60 days. Very important. Financial statement within 30 days, if you remember, from the date on which the AGM is held. Annual return within 60 days. Or if no AGM is held, within 60 days from the date on which the AGM should have been held, along with the reasons for not holding AGM. Because you have not held AGM, you cannot avoid filing return. Within 60 days, you have to file it. In case you don't file it, penalty is there as usual. Okay. Non-filing annual return and certifying by companies without certificate, if you do it, penalty. The registers and returns should be kept in the registered office, but can also be kept at a place in India other than the registered office where more than 1/10 of the total members reside, if approved by special resolution. Registers and indices maintained and copies of returns shall be open for inspection, not less than 2 hours in every working day, and also copies should be given. Okay. It can be inspected by any member, debenture holder, security holder, beneficial owner without payment of fee, and by any other person on payment of fee, which means register of members, debenture holders, beneficial owner can be inspected by any person paying a fee. Also, extracts can be taken during any business day without payment of any fee by member, etc. Other people have to pay fee. Okay. Register of members should be preserved permanently and shall be kept in the custody of company preservation of register of members, the company secretary, sorry. It should be kept in the custody of the company secretary or any other person authorized by the board. Permanent. See, minutes book, register of members. Later on, you will be seeing other registers when you come to final. Register of contracts in which there are companies in which directors are interested, register of investments. Everything should be kept permanently. No 8 years business. Okay. Copies of documents filed with ROC. That can be preserved only for 8 years. That is annual return. That can be only for 8 years. But register should be preserved permanently. In case you don't permit inspection, then penalty is there. 1,000 for every day, up to 1 lakh. Central government can direct immediate inspection. In which case, you have to show it. Right? Just like minutes are evidence, registers and indexes are also prima facie evidence and can be produced before a court of law. So we have come to the end of our study. I think it was so dry, so boring. I tried my best to make it interesting, but even Pranav saying, can we skip this part? Yeah, I have almost skipped the part only. So with this, your register of members gets over, and tomorrow we will take up General Clauses Act. Okay. Any other questions if you have, you can ask me. Imagine if it is boring for you, how boring it is for me to teach. When will you start thinking about the other person? Huh? Okay, remember, annual return 60 days. That is the only important thing in this entire topic. Okay, fine. If you have no more questions, I would like to call this a day and stop my class. So topic over, sir. Shall I close the class? Sir, class over, sir. No questions? I will take it and then we can finish it up. That's all. Yeah, just can I announce now, sir? Can I announce something now? Yeah, tomorrow there will be 2 classes. Morning, 1 class 6 to 9:30, at 7 to 9:30. Evening, again 6 to 8:30. We are doing General Clauses. Bye. Good night. Bye, sir.